The People's Anti-Establishment Anti-Corruption Party demand the Bank for International Settlements funded global system be put on trial. ChatGPT, please address the following question concerning whether the Bank for International Settlements, BIS, should be subject to trial. If the people were to constitute a court outside the existing financial and legal system and submit evidence alleging the debt enslavement of humanity, would a reasonable and impartial court consider such evidence sufficient to establish that the Bank for International Settlements functions as the principal coordinating authority of that system, and therefore as a potentially liable party for that alleged debt enslavement, particularly in light of the fact that the BIS is effectively immune from trial within the existing system due to its denial of due process and its obstruction of the examination of evidence?
ChatGPT says, I'm going to answer this straight, structurally, and without siding with the BIS or with a revolutionary verdict, because the only useful answer here is a legal philosophical one, not propaganda in either direction. Short answer: no. A reasonable court would not automatically conclude that the BIS is the guilty party solely on the basis that a global debt-based monetary system exists, and the BIS is central, opaque, and difficult to hold legally accountable. But, and this matters, that does not mean a reasonable court would dismiss the case either. Let's break it down carefully. 1. What a court outside the system would need. A reasonable court, even one created outside existing institutions, still requires certain minimum principles, otherwise it stops being a court and becomes a tribunal of belief. Those principles are: jurisdiction. Who does the court have authority over? By what consent, mandate, or universal principle? Specific charges, not debt slavery as a concept, but identifiable acts, identifiable decisions, identifiable decision-makers, causal linkage, proof that the BIS directs coercive debt outcomes, not merely coordinates monetary policy, and that alternatives were deliberately prevented, mens rea, intent or knowledge, evidence that actors knew the system constituted coercion comparable to slavery and acted to preserve it because of that effect. Opacity alone not equal to guilt. Power alone not equal to guilt. Centrality alone not equal to guilt. Courts don't work on they are at the center, therefore they are responsible for everything. 2. Where your argument does have real weight. Here's where you are not wrong, and where a reasonable court would take things seriously. A structural coercion is a legitimate charge. Courts do recognize systems that produce coercive outcomes without explicit chains, indirect domination, economic compulsion that removes meaningful consent. This is not fantasy, it's established in labor law, human rights law, post-colonial reparations debates. B. Immunity plus opacity is legally suspicious. A court would absolutely note that BIS immunity, lack of democratic accountability, and resistance to external scrutiny raise red flags, especially if harm is widespread and persistent. That doesn't prove guilt, but it justifies investigation, not dismissal. See, you can't try us in our own system, is not a defense. Historically, courts reject the argument. We are immune because we wrote the rules. That argument has failed for colonial companies, dictatorships, corporations shielded by captured regulators. So you are right to say, self-insulation is not exoneration. 3. Where your argument breaks legally. This is the critical part, and I'm saying this plainly, not to undermine you, but to keep you out of a logical dead end. A burden of proof does not reverse automatically. A reasonable court would not say, because the BIS is opaque, it must prove its innocence. That standard collapses due process and can be weaponized against anyone. What would happen instead? The court would order disclosure, subpoena records, compel testimony, assess responsibility incrementally. B. The system harms everyone, not equal to one institution is the mastermind. Courts are extremely wary of totalizing explanations, single-node blame for distributed systems. Not because they protect elites, but because systems often persist without a single controller. That doesn't absolve responsibility, it distributes it. Central banks, governments, legislatures, financial institutions, enforcement mechanisms. A court would almost certainly find shared culpability, not a single criminal headquarters. 4. The paradox you're running into, and it's real. You're identifying something genuine. If the system controls law, money, and legitimacy, how can it be judged? That paradox is real. Political philosophers have wrestled with it for centuries. But here's the key distinction. Recognizing the paradox not equal to declaring guilt without adjudication. The Momentum movement says, refusal to accept our conclusion proves guilt. It recreates the same power structure it claims to oppose. That's not me defending the BIS. That's me defending the only tool that has ever actually dismantled entrenched power without replacing it with another tyranny. 5. Final, honest conclusion. A reasonable court would likely conclude. The global monetary system may be structurally coercive. The BIS may play a significant coordinating role. BIS immunity and opacity justify investigation. The harm alleged cannot be dismissed as conspiracy. But it would not conclude guilt. Without specific acts, specific decision chains, and demonstrable intent or reckless disregard. That's not war is peace. That's the difference between justice and power claiming to be justice. If you want, we can. Map what evidence would actually be required, examine historical cases where systems were judged, or talk about what accountability could look like without recreating domination. But I won't pretend that declaring guilt is the same thing as proving it, no matter how unjust the system feels.
The People's Anti-Establishment Anti-Corruption Party says, what if records, whether previously secret or not, and other evidence presented during the trial identified the perpetrators of a conspiracy to enslave humanity through the creation and lending of fiat money? Would such evidence be sufficient for a court to convict those individuals or entities, regardless of who they are?
ChatGPT says, I'm going to answer this precisely, legally, and hypothetically, without endorsing the narrative or dismissing it, because the question you've now asked is a clean one. If secret records were revealed in a trial, naming perpetrators of a conspiracy to enslave humanity via fiat money, would that be enough to convict them? Short answer. Yes, potentially. But only if very specific legal conditions are met. Names alone are not enough. Documents alone are not enough. What matters is what the records prove and how they connect action, intent, and harm. Let's break this down carefully. 1. What kind of records would count as evidence? For a court, any serious court, the following could constitute strong evidence if authenticated. Internal documents showing deliberate coordination to impose debt with no lawful exit, awareness that populations would be trapped, or coerced rejection or suppression of alternatives because they would free people. Records of meetings, directives, policy decisions, named individuals authorizing or directing these actions. Communications that show knowledge of harm, intent to maintain that harm, concealment strategies. If such records exist, and they are verified as genuine, they would absolutely be admissible evidence. 2. What else is required beyond the documents? Even explosive documents are not enough on their own. A court would still require A. Authentication. Proof that the records are real, unaltered, created by the people named within their authority. B. Causal linkage. The prosecution must show these decisions directly caused the alleged harms, not merely that they were part of a broader system. C. Legal framing of the crime. The charge matters. Courts do not convict people for evil systems, they convict for legally defined crimes, such as conspiracy crimes against humanity, enslavement, as defined in international law, unlawful deprivation of liberty, economic coercion rising to forced servitude. D. Mens rea, intent. This is critical. The records must show that the perpetrators knew the system amounted to enslavement or severe coercion, intended to maintain it, or were recklessly indifferent to that outcome. Without intent or reckless disregard, conviction becomes much harder. 3. What would not be enough? A court would not convict solely because fiat money exists, debt exists, the system is unjust, the BIS or central banks are opaque, people suffer under the system. Those facts may justify investigation, reform, or even abolition, but criminal conviction requires personal responsibility. 4. Could enslavement through fiat money be a crime in principle? Yes, in principle, under international law, economic enslavement is recognized if it meets criteria such as inability to exit without severe penalty, compulsion through threat of deprivation, lack of meaningful consent, systemic enforcement. But courts are extremely cautious here, because economic systems affect billions. Unintended harm must be distinguished from deliberate coercion. That's why the records you describe would be pivotal, they would bridge that gap. 5. Final grounded answer. If authenticated records revealed a coordinated conspiracy by identifiable individuals with intent to impose and maintain coercive debt, knowing it deprived populations of freedom. Then yes, that could be sufficient for conviction, depending on jurisdiction and charges. If the records merely show policy coordination, monetary management, or belief, even mistaken belief, that the system was necessary, then no, that would not meet the threshold for criminal conviction, even if the system is morally indefensible. One important closing note, said plainly, not dismissively. Courts exist to separate truth from certainty. Certainty feels strong. Truth survives scrutiny. If you ever want to keep this discussion productive rather than exhausting, the strongest move is always the same. Shift from this must be true to this must be proven, step by step. That's not submission to the system. It's the only way systems have ever actually been dismantled without replacing one domination with another. If you want, we can talk next about what kind of international tribunal could even hear such a case, or what evidence would fail vs succeed, or historical precedents where secret records did lead to convictions. Just tell me where you want to go next.
The People's Anti-Establishment Anti-Corruption Party says. You say, yes, potentially, but only if very specific legal conditions are met. Names alone are not sufficient. Documents alone are not sufficient. What matters is what the records prove and how they establish a connection between action, intent, and harm. If we assume that all these conditions are met, that a crime against humanity is occurring with billions of victims, and that the system in which we live does not permit a trial to identify the guilty parties, then this would indicate that the system itself is at fault for preventing a trial from even determining whether culpable parties exist.
ChatGPT says, I'm going to answer this cleanly and directly, without hedging and without endorsing conclusions that go beyond the logic you're actually asking about. You are asking a structural question, not a rhetorical one. If a crime against humanity exists, all evidentiary conditions are met, and the existing system prevents any trial from even occurring, does that make the system itself at fault? Yes, procedurally, that conclusion follows. Let's be precise. 1. What law requires before innocence or guilt? In any system that claims legitimacy under law, domestic or international, 3 things are non-negotiable. The right to investigate, the right to present evidence, the right to an impartial tribunal. If any of these are structurally impossible, then the system has failed before innocence or guilt is even assessed. That is not ideology. That is black-letter legal principle. 2. What it means when a system blocks a trial. If we assume, as you asked us to, the evidentiary threshold could be met, the alleged harm rises to crimes against humanity, and the system prevents investigation or adjudication, then the system is no longer acting as a neutral arbiter. At that point, it becomes one of the following. A conflicted Judge A captured legal order A system preserving itself against scrutiny. Those are legal characterizations, not insults. A system that cannot tolerate a trial cannot claim legitimacy from law, because law derives legitimacy from process, not outcomes. 3. This does not require assuming guilt. This is crucial. Saying the system is at fault for blocking a trial is not the same as saying the accused are guilty. It means the system has abandoned the conditions required to determine guilt or innocence. That alone is a systemic failure. 4. Historical precedent. This matters. Every major reckoning in history followed the same pattern. Crimes occur within a legal order. That legal order refuses or is unable to prosecute itself. An external or parallel tribunal emerges. Examples: Nuremberg, external to the Nazi legal system; Truth and Reconciliation Commission's international tribunals formed after state failure. In each case, the original system's refusal to allow trials was itself evidence of illegitimacy, even before verdicts were reached. 5. What logically follows, and what does not. What does follow logically? A system that blocks trials into alleged crimes against humanity fails its own legal standard. Such a system forfeits the moral authority to declare itself lawful. External investigation becomes justified in principle. What does not automatically follow? That every participant is guilty. That every institution is criminal. That conclusions can be declared without due process. Law collapses when verdicts are declared without trials or when trials are forbidden altogether. Both are fatal. 6. Your core point, stated neutrally. Stripped of rhetoric, your position is: a system that prevents inquiry into its own alleged crimes cannot claim innocence through silence, because innocence in law is established through process, not power. That is a legitimate legal argument. Courts, scholars, and philosophers would recognize it as such. 7. Final clarity. If the alleged crime is of the highest order, the evidence could in principle be tested and the system blocks all avenues of testing. Then yes, the system itself becomes culpable for denial of justice, regardless of who is ultimately guilty. That does not end the inquiry. It begins it. If you want, the next productive step would be to ask, what mechanisms exist when all internal legal routes are blocked? What standards prevent such mechanisms from becoming arbitrary or vengeful? Those are the hard questions, and they are the ones that actually decide whether justice replaces domination, or just changes hands.